Everybody, welcome back. I'm happy to be joined today by the host of Justice Matters, Mr. Glenn Kirschner, former federal prosecutor for, just a couple of years, right, Glenn?
A few decades, but yeah, who's counting?
We all are, actually. We're all counting. Talking about counting, I want to talk to you about Bannon. But first, you were in the courtroom today as we had the what people have been calling the Trump executive privilege hearing, but which is really more of a legislative purpose hearing, isn't it?
Yeah, but of course, there clearly is a legislative purpose for what Congress is doing, what it's investigating. And Judge Tanya Chutkan, who I know from trying murder cases against her back in the day, we used to tangle in Superior Court, and she was a great public defender. She's a strong, smart, fearless attorney. She's going to get this litigation right. And importantly, she's doing it at light speed. She's not letting the nefarious litigant, Donald Trump, weaponize the delay. So I have nothing but high praise for Tanya Chutkan, and that is reinforced by what I saw today in the courtroom. Because when the defense, not defense attorney, when Trump's lawyer, Justin Clark, suggested that, well, maybe Congress doesn't really have a legislative purpose regarding all of this, she said, whoa, wait a minute. So you're saying that Donald Trump's notes and his phone calls and the logs and all of this evidence surrounding January 6th has absolutely no relation to any legislation Congress might be considering to help fix this problem. She said, this did happen right in the Capitol, in Congress's house. So I think she made pretty short order of the no legislative purpose argument, and it just sort of devolved from there.
And speaking of legislative purpose, I was wondering if the House lawyer, was it Doug Letter who was arguing?
It was Doug
today?
Letter, yeah.
I was wondering if he said, well, actually, Judge, not to use a mansplaining term, but actually, Judge, they are looking at amending the Electoral Count Act. They are working for a legislative purpose. Not that we need one, or not that it's not obvious, but did he bring up the fact that they were looking at the Electoral Count Act today?
I think he did mention that, if I'm recalling correctly. I took like 19 pages of handwritten notes, and I can only read some of them when I try to write that fast. I know he touched on the legislative purpose argument, and he may have actually said the Electoral College Count Act was one of the many ways they could go about addressing the need for legislation. So, but as I say, the judge summarily dismissed, in my view, that argument. And then she just kind of knocked down each and every argument this Justin Clark lawyer made. I guess this is not to disparage him, but this is the kind of lawyer you get when, the client never pays his lawyers. We're on, the fourth or fifth tier now of lawyers for Donald Trump.
Yeah, true. And we know that we've talked to Terry Canfield yesterday. What's being argued here is whether or not a preliminary injunction will be placed. This isn't a merits hearing, so to speak. And we know that the archives has said, well, we're going to start handing it over on November 12th unless the court tells us not to. I think Donald is facing a real timing problem here, but I can see the courts bend over backwards as they have in the past to say, we will give you enough time to file your appeal. We will grant an emergency injunctive relief, even though that's very rare and probably shouldn't be done in this case because he's not the sitting president anymore. And he hasn't even in his briefings given reasons for getting injunctive relief. He's only been arguing on the merits, which is just bad lawyering. So what do you think of all that? What do you make of that?
Yeah, so a couple of things. First of all, for injunctive relief, you need to prove that there's harm here. And the judge asked very pointedly, what is the harm to Donald Trump? And the lawyer had, bupkis. So the lawyer had to backtrack and say, well, the harm is to the office of the presidency. The harm is to the institution, to which Judge Chutkan rightly responded, well, wait a minute, who is it under the Presidential Records Act that gets to decide whether there's harm to the presidency, to the institution? That would be the current president. and he's made that decision. Former presidents don't get to make that decision. So what else have you got on the harm front? And again, the lawyer had bupkis. There really was no winning argument coming from Donald Trump's lawyer. But you hit the nail on the head on the question of, okay, during the appeal, because there will be one once Donald Trump loses, what happens? And there are two parts to that question. Let's assume Judge Chutkan in the coming days, and I think we're going to get her ruling very quickly. She mentioned that the first batch of documents, I think, are scheduled to go over on November 12th. The first question is, if she rules that the documents should be turned over and Trump's lawyer files a request for a stay, don't turn them over while we file our appeal, she doesn't have to grant that. She can say, denied, I've made my ruling, you have no legal leg to stand on. Then, of course, we'll have to run to the appellate court and seek a stay. I don't think the courts should grant a stay. Why? Because that will be allowing Donald Trump again to weaponize the delay built into the system and try to run out the clock. So here's what the court can do. And something similar to this is done all the time in criminal litigation on issues of discovery. The court can say, we are not going to stay the production of these materials. We're going to direct that they can be given over to the House Select Committee, but we're going to issue a protective order. That protective order will say something like, and it can be fashioned in any number of ways. The House Select Committee can get these materials, can begin to work with them as part of their investigation, but they can't distribute them. Maybe they can't even question witnesses yet based on what they're learning in these materials until the appellate process is further along. There are any number of ways that you can sort of split the baby. I just hope to heck the courts have learned their lesson. They don't fall right back into the trap of letting Donald Trump weaponize the delay.
Yeah, no, agreed. And I think he has less of a leg to stand on, as he's not the current sitting president, as he did with his previous legislative purpose arguments in the Mazars case or the tax case with the House Ways and Means Committee, which doesn't require any legislative purpose, but he was still able to languish that in the courts and run the clock out. I have a couple more questions for you with regards to this and Bannon and how they might be connected, but I have to take a quick break. Will you stay with me?
I will.
Thank you. We'll be right back. Everybody, welcome back. We're talking with the host of Justice Matters, Mr. Glenn Kirschner. Glenn, before the break, I had mentioned that Bannon might be involved in this as well, because I had heard rumors, and I think I talked to you offline, and also our friend Hugo Lowell from The Guardian had heard rumblings within the Congress of the Select Committee that the Department of Justice, with regards to the Bannon criminal referral for contempt of Congress, was perhaps delaying indictment until a court ruled on a legislative purpose. Now, a Bannon legislative purpose would be different from a Trump legislative purpose, but not anymore. And the reason is because in the Department of Justice filing in this Trump case, in the Trump executive privilege case, as they're calling it, the National Archives case, they mentioned Bannon and how he wanted to stop the Electoral Count. And they also, we know that the committee is looking at the Electoral Count Act. So I think if there is any delay whatsoever in indicting Bannon, which I know we're doing a indictment watch on Bannon, I think the only thing they might be waiting for is a ruling from this court, if they're waiting for anything at all.
Yeah, and I think we are always trying to find some common sense reason for the delay that is unacceptable, the delay that is dangerous to our democracy. And this is what we have come up with recently. And it may very well be they are waiting for that outcome on the legislative purpose issue. I think if they are, they're wrong. Not only are they wrong, I think they're dead wrong, because what you do when somebody is in contempt of Congress, voted in contempt of Congress, referred for criminal prosecution, the federal law says that matter shall be presented to the grand jury for its action. And the only reasonable action of the grand jury would be to indict him. Then in his defense, if he wants to argue the legislative purpose or the executive privilege or anything else, let him do it. He will lose. Hands down, he will lose. But that's not a good reason to front load delay while you try to do some legal navel gazing and troubleshoot what might happen after you indict Steve Bannon. No, let's get the justice show on the road. Let's indict Steve Bannon. Let's have some respect for Congress's power and authority to enforce its own subpoenas and make some progress toward investigating the attack on our democracy. Enough with the legal navel gazing, if in fact that's what's going on, and that's what's holding up a Bannon indictment.
Right, if that's what's going on, and we should emphasize that. And I've said the same thing. I think that there's T crossing and I dotting, and then there's extreme T crossing and I, where you try to come up with every possible scenario when you don't need it. You know, I've been saying, hey, you don't just indict people and then ask questions later. But here we have a clear violation of the law, just point blank. It is illegal. And like you said, I think it undermines the power, the constitutionally granted power that Congress has to do this. And this whole sort of, in the last year, a few years, we've seen this wedge driven in between the power of the executive and the power of Congress, and they're supposed to be co-equal branches of government. And this just would, if that's what's happening, would just make that wedge a little bit bigger, in my opinion.
And Congress neuters itself every time. I call them the treasonous 202 that voted against enforcing their own subpoena. They're neutering themselves. They're saying, please take our power. We're really a second-class branch of government, not co-equal. And, that may feel good in the moment because you think you're retaining some of Donald Trump's base, but boy, are you going to lose in the long run. You're giving away your own power.
Yeah, although I will say that, Republicans, at least the new party, the Trump Republicans, are hell-bent on destroying government. And I think that they're more about an all-powerful executive and less about a co-equal branch, even if that means themselves. I don't know. Maybe I'm incorrect.
But you know what? Dictators don't have the time of day for co-equal branches of government. So they really want Donald Trump or the next autocrat coming up behind him. Well, you know what? They might as well give up all power.
Yeah, true. Absolutely true. I thank you, sir. And it must have been just kind of amazing to be back in the court with the judge that you used to try murders against.
Yeah, it was fun, and I missed the court. And it's funny. I was talking to the head administrator of the court today because people are still dialing in because they don't realize court is open again. But even he was saying, will you spread the word that court's open? Because, we like it when people come to these public proceedings.
All right, everybody, you hear that? Court's open. Thank you so much. Everybody tune into Justice Matters. I appreciate your time. Glenn Kirschner, thanks.
All right, good talking to you.
Everybody stick around. We'll be right back with the good news.
MSW Media.